We're assuming that everybody can hear us and the audios are clear. Bangalore, well done. Thank you very much. And Geeta, hi, from Bangalore too. Great. I was in Bangalore in February and stayed there a couple of days for work. It was a great experience. Bangalore is quite, last week I watched the news that the Nita Mukesh Ambani Cultural Center was launched. So I think Bombay was, quite busy and a lot of attention. I'm sure it was a lot in the news as well. Hi, Akanksha. I can see you now. Thank you. So I think it's time. So let's get started. Good evening, everybody. Thank you for joining. And yet again, Aspire for Her, She Knows Money is back with our weekly session. And today's topic continues on succession planning. Aditi Anand, who's not new to our team and has been focused on these sessions. But today's topic is quite special. Now that we all know that succession planning is important, we've understood why that's important for women as well in all areas of their lives. Today, we're going to talk about the laws around it, what you should know, and how to perhaps exercise your laws. And as per our tradition of the session, we'll kick off with icebreaker questions that we have Steffi always curating some wonderful questions for us. And then we'll start with a poll. And after that, we would have Aditi taking over the session. Over to you, Steffi.
Thank you, ma'am. So, guys, let's get started with our icebreakers. And please don't hesitate to send in your answers to the chat box. There are no wrong answers here. So, having said that, here is my first question. What do you understand by will? Or what do you think of when I say the word will? I will wait for your answers. Right, will my wishes after I die. Accurate. Can I get a few more responses? Okay, the right to inherit or distribute assets. Absolutely. And no worry, right? We'll know what a will is anyways after today's session. So this is just a normal question. Anybody else? Okay, I think I can move on. Then my next question is, at what age do you think one should start estate planning? At what age do you think one should start estate planning? Okay, can I get a few responses, please? I would say at the age when you know that estate planning is important. So as early as you realize that it is required, absolutely. Okay, I don't see any more responses, so I will move on. I'm going to go ahead and launch our first poll now. Here, y'all can see it on your screen. It says, do you think it is important for women to make a will? Wonderful, most say yes. And some would like to learn more. Great. So I'll have this poll on for another few minutes, maybe 2 minutes. Please quickly put in your polls, and then I can end the poll. Okay, ending the poll now. Great, over to you, Aditi.
Thank you so much, Steffi. Thank you so much once again, Aspire for Her, for conducting this. A very, very warm welcome to all the women here who've taken out time to understand the value of the session today. And thank you. With that, we'll begin right away. Okay, just a quick check. Are you able to see my screen?
Yes.
Okay, thank you so much. So today is actually the fourth session of the estate planning series. We actually cannot believe that this is month 4 that we're running into, and time has simply flown by. So today we'll talk about what are the various laws which govern the space. We've culled out some really interesting case studies which will show us the position of law and how we can, learn from those cases and the practical applications in our own life. And of course, we'll also talk a little bit about why is it important to make a will. I'll just share the agenda. Needless to mention, we'll do a quick recap. So in case if some of the folks are new, they'll catch up to speed. I'll take you, like I mentioned, to the law, case studies, key takeaways. I'll also talk about the importance of estate planning for women and a little bit about yellow, and I'll share what is our passion with you. We know this earlier, and I keep repeating the data, 150,000 crores of assets are lying unclaimed. Interestingly, this was in the news in India just last week when the Reserve Bank of India shared a report which stated that 35,000 crores of assets are lying unclaimed in Indian banks itself. This does not count your shares, this does not count your provident fund, insurance, or the other aspects. This was just last week, and again, there was much debate and deliberation on why is this issue and what can be done about it. We mentioned earlier, takes a minimum of 3 years if you're lucky to get all your asset transfers done in place. Also, unfortunately, 76% of the cases that are plaguing the Indian courts today are because of property and family disputes. I'll quickly touch upon what are the several tools that are available with us. I also have an interesting case study to share with you. Okay, so let's start with the most fundamental and the humble will. Will essentially means it's a document on which you write down your assets and what your wishes are regarding the distribution. A will, again, like I mentioned, it's so important that all the other modes of estate planning take place in conjunction with a will. So you need a will even if you're making a trust. You need a will even if you've written a gift deed. So will becomes the base document. Trusts become important. Essentially, it's a more sophisticated structure in which you can plan your estate distribution. Trusts hold much value when you have goals like asset consolidation, which means that you want to bring number of assets under one umbrella, or you have families where there's a child with special needs, or you want to make a staggered distribution. Example, you want your daughter to receive, let's say 5 lakhs when she's 30, or 5 lakhs when she's 35. So these staggered payments, also trust is the good tool to use. Hopping on to the gift aspect, essentially we've seen that in India, gifting is very common, especially at the time of marriage. You've seen, daughters receive gold from their parents, or sons receive, let's say, XYZ from their family members. Important aspect of gifting is that once you give a particular gift to someone, it does not remain yours anymore. So essentially, you lose control over that particular aspect. To draw a parallel, that's not the case with a will, because a will comes into effect or becomes alive only once the person is not there anymore. I'd like to share a case study regarding a gift. So in India, we have something called as the Senior Citizens Act. So one of the important aspects of this law says, if you've given, let's say, a gift or any property to your children with an understanding that your children should take care of you, then it's important that you write it down in that document, so that tomorrow, if the children were not to take care of you, you can actually have that document revoked. This means the property can come back to you. So again, but the important point to remember is that you should mention it in that particular document. However, having said that, with a gift, it's all right to use it as one of the tools for estate planning, but we do not recommend that you gift all your assets, because you naturally should keep something for your upkeep and maintenance and independence. Moving on to nomination. You're very well aware, I know I've repeated time and again, but a nomination essentially means your nominee has the right only to collect that asset. Your nominee is a trustee of that particular asset, and the legal heirs that are defined as per the law to which you belong govern who the rightful owners are. To give you a very simple example, let's say if I've made my sister as the nominee, my sister is to receive the assets and distribute it to, let's say, my husband or children, which are the legal heirs as per law. Moving on to the last one, you must check about what are the survivorship related clauses, especially if you have a joint property. Again, to give you an example, people usually think, I have a joint property, I don't really need a will. But have you carefully looked at what your document says? We've got cases in the past where it's written 50% ownership has been clearly mentioned in the document. This means when one person passes away, that person's half the property will go as per the inheritance, and the other half will go as per, let's say, male or female, because laws are different for both. So these are the an overview of the tools, but just make sure you plan these tools as per the goals that you want to achieve. Moving on, a quick few points about why is it important to make a will. Like I mentioned, it's the most fundamental aspect. It helps you to overcome your personal laws which govern you. Again, I love to give examples because I feel it explains the point very easily. What this means by bypass is, let's say, if I don't make a will, then my husband and children receive my assets. But if I make a will, I can choose that my sister can inherit the beautiful piece of necklace which I have. So you can choose your heirs correctly. When you make a will, it becomes very easy to transfer assets from one generation to another. Essentially, when you don't write a will, there's a plethora of documentation that you need to do. You need to get NOCs, indemnities. There's something called a succession certificate. You may need a letter of administration. I know all these terms right now are sounding very technical, but to be honest, these are the documents that you need to have in place if you do not write a will, because asset transfer becomes very hard. What a will really helps is that your family can identify the assets. Today, one of the major reasons why we've seen the 1,50,000 crores is also because we are not aware of the assets that belong to our family. I always mention, do we really know what is the bank account that our parents hold? Or do we know, let's say, what is the customer ID number of the Zerodha account that your dad trades in. We don't know these aspects. And that is why in a will, all those aspects are listed down, which makes asset discovery easy. Definitely, when you have a will, it prevents disputes because there's a clear sense of direction that the person who's passed away had in mind. Especially for mothers with young, minor children, a will is the only instrument through which you can appoint a guardian. Like I've said, in COVID, we've seen quick succession, young parents have passed away, and grandparents of either sides are fighting for the custody of the child. This would not be possible. This would rather not happen had you written a will. And lastly, it gives you a power of choice. You can easily choose, let's say, a beautiful piano that you want one of your cousins to inherit who has that musical flair. So essentially, a will can empower you greatly because you can take charge of your assets and how you want your loved ones to be taken care of. We'll pause here if you have any questions. I think you're on mute, Simran.
I was saying, let's just check if there's anything on the chat. No, nothing yet. So I think let's continue.
Okay, great. Thank you. Okay, we'll be now covering what are the important estate succession, intestate succession laws that we have in India, and what are the landmark cases that have taken place. And we look at how the law has evolved over a period of time. So you're aware, in Hindus, we have the Hindu Succession Act. Over here, Hindu includes Sikh, Jains, and Buddhists. We've got Muslims under the Muslim law. One of the governing legislations is the Sharia Act that you can see. There are several others, but that really depends on which particular sect of Islam you belong to. That's why I've not listed everything here. So this is an overview. And for Christians, Parsis, and Jews, you have the Indian Succession Act. I would like to point out, just see the year in which these were legislated. 56 looks like the latest, 37 for Muslim laws, and 25 for Christians. So just imagine this, the situation and the circumstances that governed when these laws were in place. In the 20s, in the 30s, in the 50s, women barely played any role in the society, apart from probably procreation. But today, laws have, of course, slowly evolved, but are they completely there yet? The answer is no. And that is all the more reason why us, women taking charge of their estate and respective planning becomes very important. Let's look at the very first aspect. So this is essentially, this depicts who are the various family members who become a part of your estate. So let's say for a Hindu female, it's first the husband and the children. If the husband is, not there, then only the children get it. If the husband and children are both not there, then the mother-in-law gets it. If the mother-in-law is, let's say, not there, and then the father-in-law and the heirs. So this is just to give you, a snapshot on who are the family members who are involved. Your own parents only receive it much later if the husband and the children and the husband's side of the family is not there. So essentially, like I mentioned, the law has been archaic in nature. And because of that, these are the situations that we're facing today. Let's take a look at a very interesting case study. So essentially, one of the aspects that the Hindu Succession Act did not cover was tribal women, especially of the scheduled tribe. The Hindu Succession Act mentioned that a scheduled tribe will be included only if the central government is specifically mentioning it. Now, in this case, there was a lady called Nitya. She belonged to a tribal community. And for long drawn, she's been fighting for her rights in the property. Now, essentially, she was torn apart between the fact that her own customs, which were obviously dating, ages ago, did not allow her to have equal inheritance rights to the ancestral property, which was owned by her father and grandfather. She faced immense opposition from her own family, her relatives, who were essentially the male counterparts who were entitled to receive. She fought the case for decades, and then finally, this is as recent as 2023, the Madras High Court included scheduled tribes as a part of the Hindu Succession Act. And now the Hindu women of the scheduled tribes have equal right as all the others have. But again, the important takeaway in this particular scenario is that if you don't have an estate plan, if you don't have a right to make a will, see, that is one of the fundamental rights that today in our country we have a right to do. We have a right to deal with our property in whatever manner we want. And if we don't exercise those rights, then obviously the law, takes charge of the situation. And this is why it's very important. It doesn't matter what particular fragment of the society you belong to, but you must take charge and you must write a will. We'll move on to the next part. This is about Muslims. So essentially, for females, these are several heirs which are mentioned. But as a general principle of law, the brothers in the family inherit more from the sisters. So these are, again, like I mentioned, just giving you an overview. Let's examine a case. Now, this is a very common practice in Muslims where they want to plan their estate. So as per the law, a Muslim can pass on only 1/3 of the property that they own. So a common practice we've seen is that they get married under the Special Registration Act so that they have a right to take charge of the whole estate. Now, again, recently, this was in Feb, a Muslim couple in Kerala, they got married after 30 years again because they only had daughters, and they wanted to make sure that their daughters inherit everything, all aspect of their assets, and they did not want to distribute it to other relatives because their family dynamics was such. And because of that, once they registered the marriage, this was all over in the news, they could now write a will and pass on to their lovely daughters all their assets. We look at the intestate succession for Christians. And, again, this is across every single, faith that you belong to. Every single faith has the same, traditional mindset. And hence, it doesn't matter which faith you belong to. The crux of the whole situation is that we have to take charge so that we don't fall prey to, these demarcations that the laws way back in the pre-independence era has made. In case of a Christian woman, her husband and children essentially receive shares that you've seen. Husband receives 1/3 and then son receives the other. As of course the numbers change, the dynamics change. And when these people are not there, they've defined something called as a kindred and then lineal descendants, and then those people get a share of the estate. Now, this is again a landmark case which was there, Mary Roy versus State of Kerala. Initially, Christian Syrians which were there in the Travancore district, the Travancore Succession Act governed them. Now, you won't believe, when Mary's father passed away, her own brothers, like real brothers, denied her her own rights. They beat her up. If you read the case study, it'll give you goosebumps. They beat her up, they locked her away, simply because they did not want to share their estate, the father's estate, with her. And they were hell-bent on the fact that the Travancore Succession Act does not give right to women in these aspects. She fought for 30 years, and finally, the case is a little old, but finally in the 2000s is when she fought for a right, she got her rights, and finally the Travancore Succession Act became a part of the Indian Succession Act. And that is why this was historic in the moment where laws now have started changing. But is the situation still the same? The answer is no. So what are our key takeaways here? It's important that we take charge, because we cannot convey our last wishes if we don't have a will. We cannot convey our desires, that we, who we want to pass on the assets to. There's no choice that we have. The law will decide where and how your estate will pass. Unfortunately, you can't even appoint a guardian, because will is one of the most recognized instruments through which you can pass on your assets. Needless to mention, in India, we are all aware that asset transfer is very costly, and of course, it takes ages to get any result. The paperwork is extremely lengthy. Like I mentioned, you've got to gather all the heirs which are defined in the law, copious amounts of signing and paperwork and forms. This also have led to a lot of disputes when we've seen where there's no will and there's no clear demarcation. And actually, a lot of times, the assets just go unnoticed. We don't know where the assets are. And because of that, a lot of issues are faced, because parents work today so hard so that their loved ones are taken care of. And in this whole process, if you don't have a will, the assets are just lost in transmission. We'll pause here for some questions.
Let's look at the chat. Anyone? You're also welcome to unmute and ask questions. It's a small, intimate group today, so make the most of it. Sounds like there are no questions, and it is a sort of difficult topic, and also some of the real stories that you shared, they're also hard to absorb. We don't imagine that that it can lead to such extreme circumstances, and I guess the whole purpose of this education is to avoid being in those extreme circumstances. There's a question here. Thank you, Geeta. If you do not leave a will, will the legal heirs be able to receive the assets automatically?
So Geeta, actually the legal heirs do not receive the assets automatically, because you have to approach all the different institutions which hold your financial assets. Also, it depends on whether there's a nomination involved or not, because if you have a nominee, the asset transfer becomes easier. Essentially, what happens is, when you don't have a will, you need to approach the first thing. Let's say you go to a bank and let's say there's 5 lakhs fixed deposit. The bank will ask you, one is fill up all these different forms, and they'll also ask you to get a certificate from a court which will mention who are the rightful legal heirs. Because how will the bank really know who are the rightful people who are entitled to that money? So because of that, once all those court processes are over, you submit those documents in different institutions, and that's how the asset transfer takes place.
Thank you. And there's another question from Vaishali. What's the right time to make a will? I think we had that as an icebreaker question as well. And then that follows, she asks further, if there is no will, do the assets go to your spouse and kids equally? Or what's the law around that?
So Vaishali, thank you. The correct time to make a will is as soon as possible, because COVID has taught us life is uncertain and we must make sure that our loved ones are taken care of. So that's the answer to the first question. Secondly, if there is no will, I'm presuming you're a Hindu by the name and the surname. So
Yes.
if there is no will, the Hindu Succession Act, which will govern your succession. And in your case, yes, it will go to the spouse and the children equally. But having said that, even if you don't write a will, the people, even if you don't write a will, the banks will still ask you to submit some documentation because they do not know who the rightful heirs are. And that's exactly why, even if you know that, even if you want to give assets, equally to your family, you must write a will to avoid all those hassles.
Okay. Thank you.
You're welcome.
Can I ask one more question?
Yes, please.
So there is this organization called willgenie.com. So
Right.
they are my clients. And they were saying that these days you can make the will online and stuff. And, that is a valid thing. Is that true?
So basically, you can make a will online. Essentially, they generate a will for you. So this is something similar to what Yellow also does. So the will is generated for you. But today in India, digital signatures are not permitted on a will. So once, let's say you make a will on the Yellow app, I don't know how it happens in Will Genie, because Will Genie does not have an app, I think. So let's say, to give you an example at Yellow, let's say you make a will on the app, the will is emailed to you. You take a printout because let's say at Yellow, you have, a lot of security related measures. So we cannot see what you've written in your will. When you receive a copy on the email, you take a printout, you need to sign it, and 2 witnesses also need to sign your will. Only then it becomes a validly generated will.
Okay.
Yes. So tech platforms today help you to kind of, write the will, but you need to sign it, put your wet signature on that for it to become valid in India.
Sure. Thanks.
There is another question or 2 questions from Geeta on the chat. Feel free to unmute yourself. Happy to read the question, but we encourage you also to unmute and ask the question. Would you like to do that, Geeta? Would you like that I read the question?
Yes, thank you, Simran. Yeah, so my question was, hi Aditi, if it's a private document, for example, and let's say you leave a will and mention details of your assets, what would happen after the deceased, after the person's death, is that the legal heirs are going to be going around to all these agencies and presenting the same will, right? Which is going to include details about the FDs, gold, real estate, and whatever is there. Is there any way to bifurcate and segregate the will in such a way that, the basic details are available somewhere and the actual details are annexed in a separate document that probably is a little more private in terms of what its contents are?
Right.
That's my question. Thank you.
Yes, thank you, Geeta. Geeta, that's a very valid question, but I want to, bifurcate into certain parts. One is the will becomes an important document. So let's take the first part. Why is it important to mention all your assets? Is, as you're aware, we need to have enough details to identify it. Now, having said that, as a whole, even if you submit a will in the particular bank or institution, they are bound by confidentiality because you're a customer, and essentially only if they know that they've received the complete will, and they will be able to come to the conclusion that this is not a fraudulent one. So if you're concerned about security, what you can do is you don't need to mention the amount of the that you hold in the bank in your will. You just mention that my let's say bank account at HDFC Bank Mahalakshmi branch goes to so and so, because the values will as it is keep changing. For example, you don't need to mention every single piece of jewelry. What you can do is you, let's say, demarcate it into different boxes or different bank lockers, or people also make different pouches for different jewelry and demarcate it in such a way. We don't need to disclose the amounts. We don't need to disclose the value. We just need to mention enough details so that the assets can be identified. So then even if they were to, submit it wherever, it will not be a problem.
Thank you, Aditi. Clarifies very well. Thank you.
Thank you.
We have one more question again from Vaishali. Vaishali,
Yeah,
would you like-
I was asking that what are the powers that an executor of the will has, and sometimes there are more than one executor. Like generally I've seen in our families, they pick one person from the maternal side and one from the paternal side. So what are their powers, and what have you seen after the person is deceased? Are the executors who are from different families able to do justice to the will?
All right. So, Vaishali, an executor, no doubt, is a very important position. To be very honest, we actually don't always recommend having two executors, because what if there's a conflict? How does the decision making then take place? We recommend either you appoint one and you appoint a backup executor, or you appoint three executors that they will act by majority. Now, essentially, the role of the executor is simply execution of the will. That's one of the main roles. So they need to do end-to-end execution, make sure that all the wishes of the testator are fulfilled. That's part one. Part two, executors also have to take care of filing of the taxes, because a person may have passed away, let's say, in the middle of a financial year. So taxes, closing of the PAN card, closing of all the bank accounts once the asset transfer takes place. So essentially, oh, sorry. Okay, I think there's a background. So essentially, the good part is an executor is bound to carry out all the wishes that are mentioned in the will. And obviously, if you see somewhere that an executor is not fulfilling its duty, there are measures you can take. You can approach the court and you can make sure that the executor is either replaced or certain directions are given on how the executor can act. But essentially, all these powers you can mention in your will.
Okay, thanks.
Aditi, one more question. This is Geeta.
Yes, Geeta.
Yeah. Does the nominee have a timeline in terms of the execution of the will, or is this something that he can do at his convenience?
So essentially, so let's look at it that way. In India, if there is some amount of money which is lying unclaimed in a bank, for 10 years it can be there, and after that it gets transferred to something called as DEF account, which is all your unclaimed assets go there. So technically speaking, you have 10 years before which the amount gets demarcated as per the RBI guidelines. But the real question is, should you wait for that long? The answer is no, because at the time when the person is not there anymore, at the time when all the paperwork and documentation is happening, obviously once the family is emotionally kind of prepared and has made peace with certain fact, it's good to do this process as soon as you can.
Thank you.
Okay, I think we'll move on. What are the tips that estate planning tips for women? The first and the foremost, please keep all your ID proofs updated. I know this sounds like really simple and small, but I'd like to give you an example. We have a client of ours. For sake of confidentiality, I'm going to change the name. Let's say the name was Mr. Venkat. So in one document, he's Venkat R. In another document, he's Venkataraman R. In one document, he's V. R. Raman. So he has 7 different variations of his name. So I'm not even kidding you, the complications that have come in, and we're trying to get all the documents together and see how the asset transfer can be simpler. But just make sure that all your ID proofs are synchronized, your date of birth. I remember a time when Aadhaar was full of mistakes from the authorities' end. They simply wrote, let's say your date of birth was August and 80. They didn't write the first, the dates on which of the month. So just make sure that all that is updated and your, that sanity check is done. You must add and update your nominations from time to time, because this is one of the aspects we most overlook. We've nominated somebody years back and we never really reconsider, updating or checking them, whether we mentioned a nominee or no. So it becomes very important. Like I mentioned earlier, nominees are very helpful because asset transfer becomes easier. It's also a good tip to synchronize your will, beneficiaries, and the nominee. Example, if you have, let's say, 2 bank accounts and you want to give it to 2 different daughters, then you add the beneficiary as the nominee. So it becomes easy. She goes to the bank, she receives the money, and it's hers. As opposed to your relative being a nominee, relative will go get the asset and then give it to the daughters, etc. Add complete details of the assets. To be very honest, just making a will is not enough. Making a good will is also important. Again, we've got, a client recently where, the lady wrote only her house as the asset in the will. She had several other bank accounts she did not mention. So the house will go as per what the people she mentioned in the will, and the financial assets will go as per her legal heirs. So imagine the same person makes a will, but a part of her estate will go as per, testamentary succession, that is by a will, and a part of it will go without a will. So just add proper details. It becomes very useful at the time of transfer. You must appoint an executor because the operational part of it becomes very easy. If you feel that your executor may not have the necessary time or the bandwidth to take care of all the operations, you can take help of executor support services which are available. Do update your will from time to time, because our assets keep changing, our beneficiaries may change. You may come across a charitable organization doing amazing work. Let's say, they're taking care of animals, or they're looking after underprivileged, girl children. So in that case, you can add the charitable organization in your will. Lastly, keep your family informed. They should know that you've written a will, so then actually they can take the requisite steps. Yes, Geeta ma'am.
Hi, Aditi. Two quick questions. One
Please.
is for convenience of operations while person is alive and after death as well. Is it better to have a single account with nominee, or is it better to have a joint holding? So after the death, the joint holder automatically is able to manage things. That's one question. I'll ask you after you're done, maybe the second one.
Done. So we generally recommend you can have a joint holding, because in that case, let's say if husband wife are there, if one person is not there, then the other can take care. But just make sure that you've ticked the correct either or survivor clause, because either or that survivorship aspect becomes important, because when one person is not there anymore, the survivor gets all the right, as opposed to it being a plain joint account where the banks assume that both of you had 50% rights. So just make sure of that survivor. That's always good to add.
Okay, so are you still okay if it's a single account with nomination? Because then you have
100%,
the complete
100%.
independence, with
100%. Yeah, that is also good, because you brought up joint account. I said it's good. 100%. Your own bank account is also good. See, for example, I own a joint account with my husband, but I also have my independent account. So, it's about just maintaining that balance. And of course, it all depends on the dynamics of the family. But again, you have a single account, you have a nominee, and you're good to go.
Thank you. My next question is, when you write a will, you're mentioning that it can be updated multiple times, right? So it's ultimately a single sheet of paper that you're writing at home and keeping it safe somewhere, and you're editing it every time. Does it hold the sanctity of when I compared against a will which has two witnesses who've signed on it, to authenticate that? So every time you're going to make changes to that will, you're going to have those witnesses sign again when you make a change, right? So
Yes.
what's the best way to keep a will valid and authenticated, at the same time being able to edit it as many times until it satisfies, what you want to do as distribution?
Right. So Geeta ma'am, see, it's important to understand the rationale of having the witnesses in place. A witness becomes very important should your will get challenged at any point of time. The role of the witness becomes important because a witness certifies that they saw you execute a will, and hence this is the valid will. It was not, the signatures were not taken out of some pressure or coercion. However, because you're updating your will from time to time, it's only reasonable that your previous wills become invalid. Because then what if you changed your mind? Let's say in the very first draft, you wanted to give a very loyal maid of yours 1 lakh rupees. Now, after 2 years, you realize that, no, you know what? I think she's not treating me well anymore. So you want to change it. So it's good to, do that process again and update it and have, fresh witnesses and do it. But as it is, on an average, to be very honest, we recommend once a year, you should just take a look at your will and you see if it needs any changes. It is not every time that, we've noticed that people change their will even when they revisit it every year. Generally, it's once in 2-3 years that people actually discard their old will and make a new will. Now, I also want you to imagine one situation. What if your witness doesn't live in India anymore? Or what if your witness is not around? So in that case, as a complete process, we always recommend end to end, just finish the process. So, you have peace of mind.
So are we still okay if there are no witnesses in your will? It's just a sheet of paper that you've signed.
No, that's not a valid will. You'll have to
I
get
see.
it witnessed.
Okay.
Yes.
Okay.
Yes.
So at least one witness or two?
Two witnesses, minimum two witnesses.
Okay, thank you.
Yes, thank you. Okay, I'll take a minute to talk about Yellow. So essentially, the founders of Yellow identified several problems that were plaguing this space. One is there was lack of awareness on this topic. Secondly, even when people wanted to make a will, access to lawyers was a big problem. Being a lawyer myself, I can vouch for the fact that you go to a lawyer's office, it's expensive, it takes a lot of time to make your will. And in that process, it was noticed that because the first experience was so tiring that people stopped updating their will. And lastly, there's one big issue that the founders identified was there was no support in asset transfer. I've made hundreds of wills for customers in my life, to be very honest. But nowhere, when I was a lawyer, I would make a will, hand it over to the client, and my work was done. However, this gap was identified, and hence at Yellow, we have a solution which helps you post demise as well, which means you can approach Yellow and Yellow will do all the paperwork for you. I'll just explain that in a bit. So let's look at the Yellow app part. This is first of its kind app in India, in which you simply download the app. You can see a QR code there. Please feel free to download it. You add in the details, your family details, details of your assets, who do you want to distribute it to, and the name of executor, etc. Let's say you've added all the instructions. You click on Generate Will. It is sent to you on your email. It's again password protected. Yellow can't see any data because this is 256-bit encryption. This is the highest standard of security measures which are today currently applicable in the banking and financial space. Once that will is done, you take a printout, you sign it, and that is when it becomes a valid executed will. This is the during lifetime aspect. Yellow also has something called as post demise, where asset transfer assistance is provided. So all the assets in India, were located in India. We've got 500 agents doing the on-ground work and helping you with paperwork, with documentations, filling up of forms, getting your legal processes sorted out. So this post-demise services are applicable in both the cases, whether a person has left a will or the person has not left behind a will. We help with everything. And lastly, today it's so affordable to make a will. For $8.99, you can actually make a will. We've got like a couple of plans on the website. You can check it out and then choose which is the most appropriate for you. So in the starter pack, you have a simpliciter will. Just like I mentioned, $8.99. In the next plan, you get a will and you get 2 expert calls. And in the third one, you get some asset transfer support as well. So like I mentioned, you can check it out and select what is more applicable. And lastly, on those plans, for Aspire for Her, we have an additional 15% off. So you can go on the website at the time of checking out, just put in the code and you'll get an additional off. And yes, I'm more than happy to address if you've got any more questions.
No, it's great. We've had quite an interactive session, and given that we have 5 minutes left, I think we could do our closing poll.
Yes, I will go ahead and launch our poll. Okay, the poll is on your screens. It says, do you think the session has helped you better understand the laws governing women in succession matters? Most say yes. Can we get a few more people to put in their votes? I will be ending the poll soon, so please go put your votes. Okay, ending the poll now. Great. Yep. Yep, the poll has ended. So you can carry on.
You're on mute, I think, Simran.
Oh dear, I'm sorry. I tried to follow the etiquette well online. So I'm saying, well, we've got 3 minutes left. If there are any last minute questions you want to ask Aditi, please go ahead, before we close the session. It's been a great interactive session, and lots of questions that come up. And sometimes you think that, oh, I'm not thinking like that, and other people are thinking. So that's equally, very good learning. And thank you, Vaishali. Thank you, Geeta. I very much appreciate that you enjoyed the session and you appreciate the learning coming out of it. I know Aditi is very passionate about the subject, and she's never, ever concerned about the number of people coming in the session. And she has a mission that even if she can impact one life, she would find it, all worth it. So if there are no more questions, I would say thank you so much, Aditi, and Team Yellowbird behind. And as you rightly said in the beginning, time's flying and it doesn't even feel like that we've known each other for 4 months. Feels like we've known each other for a long time.
I know.
And it also, Yellowbird is also doing very well in their mission. And a lot of people in India are adopting to making the wills and also doing that digitally. So great work that Yellow is doing. And once again, huge thank you that you decided to partner with us and do these sessions with us.
Thank you. Thank you so much, Simran and team and Aspire for Her for giving us this platform and opportunity, because we truly feel that, we can work together, partner, share knowledge, spread knowledge, because somewhere the synergy is synchronized.
Indeed.
Yes.
And we have, of course, one more session with Aditi and Yellow in the next couple of weeks. And I will not be able to announce our next session as we are working through our next speaker and content partner and topics. But very soon, early next week, it will all be on our social media. So you can follow up from that. And we will continue the journey. Thank you very much. Thank you, everybody who joined. Have a lovely evening.